Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hey everyone, it is Pam Esquire, also known as your law intellect. Welcome to the channel. I do have it streaming from both of my platforms. I have the law intellect and I also have social media jurors because typically on the social media jurors, I deal with a bit of ghetto-ness. Okay, we have the law offices of Hood and Ghetto over there. And because it looks like LA Reid is going to need a lawyer. I figured that if some of the people over there on social media, juror, that platform, they can contact him and to say that you're going to help support him in this matter. Yes, you heard me right. The former executive of Arista Records is headed to trial on September 8th, 2025 is the day set for jury selection. And prior to, by February, his attorneys were attempting to withdraw, and he had some heavy hitters. He had Sean Holly in them. And apparently, he didn't have the money to pay him. But we'll get into that. For those of you that don't know what I am talking about, I covered a case around the same time that a lot of these cases were being filed against these celebrities. We got focused on Sean Combs. Why? Because, of course, the Cassie lawsuit was the bombshell of all bombshells. And then they just kept hitting them and hitting them and hitting them and hitting them. And I remember every single day I was coming live talking about a new lawsuit. Where one of these lawsuits was by Drew Dixon against LA Reid, and it's kind of got lost in the sauce, but they are headed to trial. Okay. And he is headed to trial on his own, and he's going to need some help. He's going to need some help. I don't know how he plans on doing it over there in the Southern District of New York without having any assistance. So, any of you social media jurors that may have any advice, he may need it. So, what I'm going to do is I'm going to go over the trial brief so you guys can know exactly what I am talking about. And so, I want you guys to do me a favor and hit that like button so people will know that we're on. Looks like you see some people that wasn't getting notifications before, look like you're getting it now. I don't know if YouTube just goes eeny, meeny, miny, mo. You get a notification. Eeny, meeny, miny. I don't know. I really don't know. But I'm grateful to each and every one of you that are here. And we are about to go over this right now. You want me to go help them? I don't know. The 11th hour like that? Y'all ain't about to embarrass me and drag me on the internet talking about Pam Esquire, the law intellect. She said she was a good attorney. She went over there. She didn't even know what she was doing. She was fumbling on cross-examination. Y'all not going to embarrass me like that. Now, it's all fun and games on the internet, but that's real life. Won't catch me slipping. Not a black woman that's in the 2% of the population of lawyers. Won't be me. I don't like them like that. Now, I might sacrifice my reputation for some of you all because you guys have been faithful over here. But LA Reid, absolutely not. Not doing it. Miss HLS, thank you so much for the super chat. You said, let's get this party started. Yes, please do. Please do. I want you all. We have our regular 5 super chat goal. And I need you all to be so kind as to contribute to the goal. Thank you so much. All right, y'all can clear. Yeah, that's the link to the second channel. We don't go over there as much as we should, but this definitely deserved to be over there. But I did start it here first, so I was like, okay, let me just go ahead, and we may have to revisit this over there on the other channel. So for those that don't know what happened, you know I'm always gonna give you the rundown. Don't worry about it. I got you. So this is the background, and this is directly from Miss Dixon's trial brief. This is over there in the Southern District of New York. You know, they are over there rocking and rolling at the mother court. So this is the introduction. Miss Dixon intends to prove at trial that defendant Antonio Marquise L.A. Reid actually abused her through a system of actual assault, sexual harassment, retaliation, and coercive control while he was her boss at Arista Records. The evidence will show that defendant actually assaulted Miss Dixon on 2 separate occasions, once on his private plane and once in his car. The evidence will further show that defendant falsely imprisoned Miss Dixon when he actually assaulted her, and that with his actions, defendant intentionally inflicted emotional distress on Miss Dixon. Finally, the evidence will show, in my clear Huxtable voice, that defendant committed a crime of violence motivated by gender, violating New York City's Gender Motivated Violence Act. Remember, that's where a lot of these older allegations are coming in at because of this statute. The following claims remain to be tried before the jury. So these are going to be the claims. This is what's going to be on the verdict form. The defendant's commission of actual assault and battery against Miss Dixon as defined in Article 130 of the New York Penal Code. So that's going to be the first one. Was there an actual assault and battery against Miss Dixon? Did defendant falsely imprison Miss Dixon? Another issue that the jury is going to consider is, did the defendant, L.A. Reid, cause intentional infliction of emotional distress? The last cause of action that will be addressed by the jury of his peers over there in New York is, did defendant commit a crime of violence and a crime of violence motivated by gender in violation of New York City's Gender Motivated Violence Act? So let's get into the factual background. So the court is familiar with the background of this case. Miss Dixon is a talented music producer, executive, and entrepreneur who helped create hits such as American Boy by Estelle featuring Kanye West, My Love Is Your Love by Whitney Houston, My Love Is Your Love. Okay, she got some little heavy hitters under her belt. Maria, 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 and A Rose Is Still a Rose by Aretha Riri Franklin featuring Lauryn Hill, just to name a few. In April of 1996, Miss Dixon began working at Arista as a senior director of artists and repertoire, A&R, and then vice president of A&R for Clive Davis, an industry-leading music producer and CEO of Arista. Every time I think about Clive Davis, I think about when TMZ came up to him and was like, Clive Davis, what do you think about what's going on with Diddy? He was like, who? Who is that? And whoever was with him was like, come on, let's go. Okay, they got up out of Dodge real quick. Won't get no statements from me, bro. Anyway, while working for Davis at Arista, Miss Dixon was successful and prolific. She signed an artist shortly after starting, which was unheard of, and she consistently found big singles for existing artists. In 1999, Arista's leadership announced that defendant will replace Davis as CEO of Arista. Miss Dixon initially agreed to move to Davis's new label, But a kidney cancer diagnosis coupled with pressure from Straw Zelnick, defendant's boss, and defendant himself made her reluctant to break her contract with Arista and leave. She agreed to continue working at Arista under defendant's leadership. Soon after defendant became CEO of Arista, his coercive control of Ms. Dixon through sexual harassment, intimidation, retaliation, and sexual assault began. What started as inappropriate flirting and comments quickly escalated to fondling Miss Dixon under her shirt, kissing her neck, and inviting her to his hotel room. Defendant actual abuse reached a boiling point during a flight to Puerto Rico on his private plane. Shortly after defendant became CEO of Arista, he announced a company-wide retreat to Puerto Rico. Karen Quack, defendant's person in A&R administration, instructed plaintiff that she did not need to book a commercial flight because the senior staff would be flying on a private plane to meet and plan presentations. This was a trap because when plaintiff arrived at the airport and boarded the plane, no other Arista staff member or execs were there. Plaintiff hid in the bathroom to wait for others to arrive, but eventually she was told to exit. Having finally gotten plaintiff alone and after trapping her on his plane, defendant actually assaulted her. Once they arrived in Puerto Rico, plaintiff stayed in her assistant's room during the retreat and avoided Reid. She flew back to New York on a commercial flight to avoid flying back with the defendant. Following the Puerto Rico retreat, defendant was armed with the threat that he would sexually assault plaintiff if he got her alone. He continued his cycle of sexual harassment, coercive control, and retaliation by sabotaging Ms. Dixon's work projects when she refused to visit his hotel room. After 10 months of defendant rejecting her work and music projects, Ms. Dixon agreed to ride in her car to play a sample by Alice Smith, another young artist she discovered. During this car ride, defendant actually assaulted Ms. Dixon again. After the assault, Ms. Dixon was depressed and suicidal. Still, she continued to try to do her job as vice president of A&R by bringing John Legend and Kanye West to audition at Arista. But defendant sabotaged those auditions as well. For Legend, defendant offered Ms. Dixon the budget to book a rehearsal space for Legend to perform for him live and even said he would bring other Arista staff members as well. But the day of the audition, defendant canceled and no one from Arista's senior staff besides Ms. Dixon attended the audition. For West, defendant allowed West to audition for him, but he then dressed down. Ms. Dixon in a room full of other Arista executives telling her that she was bad at her job and that the audition had been a waste of his time. Helpless in the face of defendant's cycle of sexual abuse, sexual harassment, coercive control, and retaliation, plaintiff quit her vice president of A&R role at Arista and enrolled at Harvard Business School, but remained a consultant for Arista for the next 2 years to maintain a salary and health benefits. Those are the facts of this here case. You said, does Reid support? If not, let him represent himself. You know what? I am going to show you all where the whole representation thing happened. Well, that's going to be the next document. Okay, let's go on. Make sure y'all hitting that like button. The argument here, New York law and the evidence at trial will show that Ms. Dixon is entitled to a verdict in her favor on all counts in her complaint. First, Ms. Dixon will prove defendant actually assaulted her, as explained in Ms. Dixon's opposition to defendant's motion to dismiss and strike, which the court denied. So they filed a motion to dismiss and the court denied it. Defendant's actions constitute actual offenses as defined in Article 130, including but not limited to aggravated actual abuse, criminal actual act, forcible touching, actual abuse, actual assault, and actual misconduct, and as much as defendant intentionally and forcibly digitally penetrated and touched actual and intimate parts of Ms. Dixon's body for his own actual gratification. In addition to satisfying the elements of numerous sections of Article 130 as required under the ASA, the evidence at trial will also show that committed an actual battery under New York's legal standard. To recover for battery, a plaintiff must prove that there was a bodily contact, that the contact was offensive, that it was wrongful under all the circumstances, and that the defendant intended to make the contact. Here, Ms. Dixon's allegations more than satisfy this evidentiary requirement. Ms. Dixon will also prove that the defendant falsely imprisoned her to state a claim of false imprisonment. So this is all that the jury will be considering when they're back there deliberating. If all the testimony, all of the evidence presented proves these elements, then he will be found liable. This is a civil case. This is not a criminal case. So it's not about guilt or not guilty. He won't be going to prison, but he might get hit with his pockets if this is proved by a preponderance of the evidence. This is not beyond a reasonable doubt. So to state a claim for false imprisonment under New York law, plaintiff must show, 1, that the defendant intended to confine her. 2, the plaintiff was conscious of the confinement. 3, the plaintiff did not consent to the confinement. And 4, the confinement was not otherwise privileged. Here, the evidence at trial will show that defendant falsely imprisoned Ms. Dixon on 2 separate occasions on his private plane and in his car. Ms. Dixon testified that as part of defendant's scheme to confine her, Karen Quack, defendant's right hand at Arista, instructed her not to book a commercial flight for the retreat because defendant was flying Arista senior staff on a private plane. And then they have some redactions of, I guess they must have deposed Miss Quack, and it must be under seal. So we can't read it. Y'all know what these redact. Y'all know they just don't want us to see it. In the face of Ms. Dixon's clear memory how she ended up on defendant's private plane, defendant and Quack's vague denials and memory lapses will not be persuasive to jury. So apparently she must be saying she don't recall. They must be doing the woody on them. I don't recall when they were at the deposition. So they're saying their vague memory ain't gonna work in front of this here jury. Ms. Dixon will prove defendant intentionally inflicted emotional distress on her. At trial, Ms. Dixon will also prove that the defendant committed the tort of intentional infliction of emotional distress. Again, this is the plaintiff, Drew Dixon's trial brief. Now, the other side, the defendant typically does one as well, or you usually do it jointly on, but hey, I don't know what's going on because he's pro se according to the docket. The elements of intentional infliction of emotional distress are 1, extreme and outrageous conduct, the intent to cause or the disregard of a substantial likelihood of causing severe emotional distress. 3, causation, and 4, severe emotional distress. This is what the jury will be considering if the facts were proven during the course of the trial. Here, defendant's conduct in forcibly touching and making bodily contact with Ms. Dixon by filing her beneath her clothes and subjecting her to digital penetration without her consent on 2 occasions was extreme and outrageous and caused plaintiff severe emotional distress. New York courts routinely find that such behavior is sufficient for consideration by a jury on an intentional infliction of emotional distress claim. And they cite Cowan v. City of Mount Vernon, which held that denying defendant's motion for partial summary judgment on plaintiff's intentional infliction of emotional distress claim because plaintiff not only alleges pervasive sexual harassment, but instances of battery. So specifically, plaintiff alleges that Miller physically touched plaintiff in an sexual manner, including filling her back, pinching her buttocks, slapping and or squeezing her buttocks, grabbing her chest, and rubbing his crotch against hers. This is the case that they're using to support their argument. Moreover, when Miller locked plaintiff into his office and exposed his genitalia to her, Miller pushed plaintiff away from the door and blocked her from leaving. These instances of battery, many of which plaintiff alleged were repeated over nearly a year-long period, constitute extreme and outrageous conduct. So they're coming with the case law that supports that L.A. Reid, according to them, engaged in extreme and outrageous conduct, and she should get paid for it. Okay. Then they had another case, Sawamimio v. DAOR, which pretty much supports her claim as well. Okay, Ms. Dixon expects the evidence at trial to show the defendant acted extremely and outrageously with an intent to cause her severe emotional distress, and that he did in fact cause her to feel severe emotional distress. They say Ms. Dixon will prove defendant violated the GMVA. The GMVA provides a civil cause of action for injury by an individual who committed crimes of violence motivated by gender. The term crime of violence is defined as an act or series of acts that would constitute a misdemeanor or felony against the person as defined in the state or federal law. If the conduct presents a serious risk of physical injury to another, whether or not those acts actually resulted in criminal charges, prosecution, or conviction. The term crime of violence motivated by gender is defined as the crime of violence committed because of gender or in the basis of gender and due at least in part to an animus based on the victim's gender. This section was adopted verbatim from VAWA, and they cite Brees v. Haggis. The evidence at trial will show that defendant has committed numerous crimes of violence motivated by gender against his female subordinate. The next thing, they say Ms. Dixon will prove she is entitled to punitive damages. Punitive damages are available in assault actions. Go see Matthew v. Garrett. That supports that statement. Such damages under New York law may be assessed where a defendant's actions evince a high degree of moral culpability or demonstrate a wanton or reckless disregard for the rights of the plaintiff. Solis Vicuna v. Notius, and that's another case over there on punitive damages. Punitive damages are also available under the GMVPA, Doe v. Olive Leaves, Inc. They got punitive damages in that case. In this case, the evidence at trial will show that defendant's numerous instances of assault and harassment against his female subordinates evinces a high degree of moral culpability and that a sizable punitive damages award must be assessed against him to deter future conduct. So they going for millions on millions. And it is well settled, in fact, the evidence of a defendant's net worth is properly considered given the goals of punishment and deterrence served by punitive damages. So they want to put in his financial records to show how much money he got. So, jury, you can consider these multi-millions and these whatever he owns and all of that. I don't know. I don't know what he owns, but they say you can consider that. That's why there was a fight, it looks like, where he was trying to keep away his financial record. He was trying, and they're compelling it, trying to get trying to get L.A. Reid, which apparently, according to conversations that appear in some of the documents, that he hasn't been the most cooperative person, according to them, when it comes to participating in this case. So they say evidence of wealth is generally inadmissible in trials not involving punitive damages. Similarly, courts have been instructed to consider the wealth of the defendant under New York state law when evaluating punitive damages to serve their purpose of punishing and deterring defendants and others from similarly willful or outrageous misconduct. Because the defendant's ability to pay impact whether damages are sufficient to function as a punishment deterrent. So these are our cases that support their request for punitive damages. Deterrence. Thus, evidence of defendant's wealth will be proper for the jury to consider at trial when determining a punitive damage award. So now they're going to anticipate the counter arguments, and they're saying they're going to fail. They're not going to work at trial. We don't care what they're talking about. Thank you, Darlene, for supporting the channel. I appreciate it. We don't care. We don't believe whatever arguments he come with, they're going to fail. That's what they're saying. Again, this is just the plaintiff's position in this matter, and that's that. Ms. Dixon expects defendant to argue at trial that because Ms. Dixon referred to defendant's sexual harassment of her in previous statements and didn't always refer to his sexual assaults, somehow means that they didn't happen. The evidence at trial will show both the absurdity and falsity of this argument. At deposition, Ms. Dixon testified countless times that her past references to defendant's sexual harassment included not only his inappropriate verbal overtures towards her, but also his forced kissing her, touching her hair, groping her, and digitally penetrating her on the plane and in the car, as that was how she and countless other laypersons defined harassment in this colloquial sense. See harass, the Merriam-Webster dictionary. Harass means to create an unpleasant or hostile situation for especially by uninvited and unwelcome verbal or physical conduct. Examples of this testimony, which Ms. Dixon will give at trial, include, we don't get to see it, it's redacted. Okay. And they got an expert that say Ms. Dixon's testimony is supported by Dr. Raghaven's expert report, where she explains, redacted. At bottom, regardless of the noun or adjective Ms. Dixon used to describe the assaults at defendant's hand, the outcome is the same. Forced digital penetration, her vulva and vajayjay constituted sexual assault. So it sounds like they believe that L.A. Reid is going to say, listen, she's done countless interviews and all she says is it was alleged sexual harassment in the workplace. Now she's basically, the story has evolved over time, where now you're actually talking about battery and getting on planes and being kidnapped or false imprisonment and digital penetration and all these other layers you've added from when you've done other interviews, I guess, bashing L.A. Reid. Apparently, this is new information, is what they're saying that their argument is probably going to be. That's what they anticipate the defense is going to be. Well, why didn't you say anything like this before in all of your interviews? You only said it was sexual harassment at the workplace. So then they go on to say, to be sure, Ms. Dixon did tell other persons that defendant not only harassed her, but digitally penetrated her against her will. So there's going to be other people that's going to say, oh yeah, she let me know back then. But we don't know who those people are because you guessed it, it's redacted. And to be certain, defendant did also actually harass Ms. Dixon as part of his modus operandi, his MO, and intertwined systems of actual misconduct, coercive control, and cyclical retaliation, all resulting in his actual assault on Ms. Dixon. But none of Ms. Dixon's statements as to defendant's actual harassment of her precludes or changes the fact that defendant actually assaulted her as well, which the evidence adduced at trial will confirm. In conclusion, for all the reasons outlined above, defendant is liable to Ms. Dixon on all claims in her complaint. So that is what the trial is about. We'll see how this works out for him. Thank you, Granny Great, for the super chat. I appreciate it. And I can't read the name on your title here. So I'm just going to read your statement. Usually people who represent themselves get convicted because they come off as arrogant. No lawyer is good enough. They have gotten away with years of abuse in the industry. I do believe it is possible. So this is a civil case. This is not criminal. So there won't be any convicting. Nobody going away in handcuffs. You might go away with your pockets a whole lot lighter than when you first came in, but this is not a criminal case. Okay. And again, he is As he sits here, these are just allegations until it goes in front of a jury and they make the decision based on the facts at trial. I am just shocked that LA Reid is having these type of difficulties on having someone actually represent him. So just imagine how much money Diddy is out here spending. He has a lot of cases of which his attorneys are juggling all of them. Diddy has money, apparently. So this is how we know that he is going to be representing himself as of now. Now, something may happen. There was a status conference, okay? And when was this filed? This was filed yesterday, August 19th of 2025. Well, day before yesterday. Today's the 21st. So the Honorable Jeanette A. Vargas, the U.S. District Judge over there in the Southern District of New York, recapped the status conference. And this is what occurred. So on June 9, 2025, attorney Sean Holly Esquire, Gregory Korn Esquire, and Suanne MacIsaac Esquire, and Kate Mangles Esquire of the firm Kinsella, Holly, Iser, Kump, Steinspear, LLP, individually and collectively defendants counsel, or Kinsella Holly, moved for leave of this court to withdraw as counsel of record for defendant Antonio Marquise L.A. Reid. On July 9th, 2025, the parties appeared for a hearing on the motion to withdraw. As explained by the court at the July 9th hearing, and as further stated in the court's July 10, 2025 order, Kinsella Holly had demonstrated good cause for withdrawal, but was to remain as counsel for limited time, solely to ensure completion of outstanding discovery, including financial discovery, and the submission of the joint pretrial order due on July 21st, 2025. So they asked to be withdrawn out of the case back in June. There was a hearing on July 10th, and the court said, there is good cause. However, we want to wrap up this discovery, so we'll have everything completed by trial. So can you stay on until we finish the discovery, and then you'll be able to be relieved out of this case. The July 10th order further ordered that, quote, upon completion of the aforementioned tasks, Kinsella Holly shall promptly notify the court, at which time the court intends to grant Kinsella Holly's motion to withdraw. This court made clear that Kinsella Holly is not responsible for representing plaintiff at the final pretrial conference on Monday, August 25th, 2025, or for submitting any of the other pretrial submissions due under the scheduling order, or this court's individual rules and practices in civil cases. On August 19, 2025, the parties submitted a joint status report and appeared for a joint status teleconference with the court. The court now grants the motion to withdraw, subject to the requirement that counsel serve a copy of this order on defendant Reid by the end of the day tomorrow, August 20th, 2025, and file proof of such service by Thursday, August 21st, 2025. Trial will proceed as scheduled beginning Monday, September 8th, 2025. Defendant Reid is on notice that September 8th, 2025 is a firm trial date and will not be moved. Defendant Reid is ordered to appear at the final pretrial conference scheduled for Monday, August 25th, 2025, as well as at the trial schedule for September 8th. If defendant Reid, either personally or through new counsel, does not appear at the final pretrial conference, defendant is hereby on notice that the court may permit plaintiff to move for a default judgment as well as pursue other potential sanctions. So if you don't show up, you might just lose by default and get a judgment against you and sanctions. As new counsel has not yet appeared on behalf of defendant is now deemed to be proceeding pro se. All parties must familiarize themselves with the court's individual rules and practices in the civil pro se cases, which are attached to this order and available on the website. Pro se parties may not call the court directly. Any questions should be directed to the pro se office. Pro se parties are encouraged to consent to electronic service. So these are the rules about when you become a pro se litigant. And there's that. So Sean Holly Esquire, Gregory Korn Esquire, Sue Ann McIsaac Esquire, and Kate Mangles Esquire of the firm Kinsella Holly Iser Kump Steinspear LLP as counsel. So that's that. He's out on my own. Thank you, Thais, for the super chat. I appreciate that. Hey, KK Scorpio, thank you so much for the super chat, hon. I appreciate it. On my own. Celebrity GoFundMe. If he asks for, if you're going to do this, maybe it's a strategy to just default so he don't have to pay. So allegedly and apparently, and I have to double check it because I think I read it somewhere, but these cases start blending together. I feel like he was going to sell a house or something and it didn't sell. It was something with some financial kind of issues that ended up popping up. But I might be mixing that up. But let me look his case up right quick. But that's it. So trial will be set. I thought I was going to go see Sean Holly in action. I'm not going to lie. I was going to go watch that. And then this happened. He'll be representing himself. You guys also know on Monday, Cardi B will be in court. Y'all remember that case, the assault case that Cardi B had? I'm going to pull that up in a minute too. Hold on, let me see. Since we got a little bit of time here. I can't remember. Where did I get that? I wonder, he might just not show up and be like, shoot, let me get this good default. It is what it is. I don't know. Somebody in here. Is this, how old is this? Somebody's in here trying to pro hack in. Hold on a second. Let's see. Oh no, that's for Drew Dixon. She done added more ammunition to her. She has a lot of attorneys on her case. They going hard on this case. So there's that. Hold on one second. Make sure I ain't pulling up my own cases. I got so many cases on here. Hold on. All right, let me pull up. Yeah, no, the Cardi B. Hold on, let me pull up Cardi B. Since we all out here talking about the cases. Let's see right quick. But yeah, she's on her way to trial on Monday, and allegedly she's supposed to testify. So that should be a hoot. And she lost her motion to dismiss, so that's why. So this is what had happened. Let's pull this one up. When someone mentioned GoFundMe, that made me think of when a date with Umar. Okay, hold on. It's been a minute since the Cardi B thing happened, but yeah, hold on. Let me. So this was filed in 2020. Y'all not keeping up now. Y'all not keeping. keeping up with all these lawsuits. So the plaintiff, let's see what he alleging. Hold on, because I don't want to put no. First cause of action is assault and battery. Plaintiff realleges each and every allegation and all that good stuff, 1 through 6, which basically says like their residency and all of that, which is none of our business. On or about February 24th, 2018. Oh, you're right. We wasn't filed till 2020, so it was 2018. So on or about February 24th, 2018, plaintiff was lawfully working as a security guard on or near the premises of the subject property when defendant Cardi B, you know, I jack her name up all the time, assaulted and battered plaintiff by violently, unlawfully, intentionally, suddenly, and maliciously striking her about the head, face, and body, placing plaintiff in great fear for her life and physical well-being, and legally causing plaintiff to sustain injuries and damages as hereinafter described. The defendant also spit on the plaintiff and used multiple profanities and racial slurs against plaintiff, who is African American. The defendant then used her celebrity status to get plaintiff fired from her job as a security guard. Defendant security guard named herein as Doe 1 also assisted in causing injuries to plaintiff at the direction of the defendant. In doing the acts as alleged above, plaintiff believes that defendant intended to make harmful contact with plaintiff's person. At no time did plaintiff consent to any of the acts of defendant alleged herein above. As a factual and legal result of the aforesaid conduct, plaintiff was hurt and injured in her health, strength, and activities, sustaining injuries to the plaintiff's body, shock and injury to plaintiff's nervous system and person, which said injuries have caused and continue to cause plaintiff great mental, physical, and nervous pain and suffering. Can we just speak plain English here?
Of course.
Said they mess with her nerves. Plaintiff is informed and believes, and based upon such information and belief, alleges the said injuries will result in some permanent disability to plaintiff, all to her general damages in a sum which exceeds the minimal jurisdictional limit of the court, according to proof at time of trial. As further factual and legal result of the aforesaid acts of defendant, and each of them plaintiff require and for an unpredictable period in the future will require the services of doctors, physicians, nurses, hospitals, and the like related to professional services, including drugs, medication, MRI scans, x-rays, and have and continue to incur medical and incidental expenses according to proof. The aforementioned acts of the defendant were committed and done willfully, wantonly, and maliciously, and said intended acts were oppressive and committed in complete disregard of plaintiff's rights, feelings, and well-being. Okay. Then they got intentional infliction of emotional distress. We got a factual base. Negligent hiring, training, supervision, and or retention of employees. Negligence against all defendants. False imprisonment. Violation of the Bain Civil Rights Act. What are the act? Where's the factual summary in this joint? Because they look like they just got. Hold on, let me look up the 2018 assault case.
Was that the one bill?
No, man.
That was 2018.
Yeah, that's the year you were born, yes.
Then that's attended gave birth.
She had that. She got sentenced in 2018 too, huh? For the strip club assault. Cardi B stripper, security guard. Okay, here go Billboard. Let's see if they're gonna make me pay for something. Of course, you gotta subscribe. I'm not subscribing to nothing. It's not that serious.
It's totally waterproof. If I spill water. Reid is wholly waterproof. I see. If I spill water, then it still works, but even when it's wet.
Okay, let's look at what ChatGPT has to say. It's a poorly written complaint, in my opinion, but hey. Yeah, I'm not doing no paywall. I ain't that deep. So according to ChatGPT, the allegation is Cardi B is accused of physically and verbally attacking security guard Imani Ellis at a Beverly Hills medical center in 2018. Ellis claims she was struck and suffered injuries. While Cardi B alleges Ellis was the aggressor and was trying to film her while she was pregnant. So this is a person, you know, Cardi B tried to keep it all under wraps. Let me see if I can pull this up. Oh, that's not fine. I won't be looking at that one. So it has, so jury selection again is scheduled to start on Monday, August 25th, 2025. Okay, they got some pre-trial rulings. A LA County judge granted several key requests from Cardi B's legal team on July 30th. So it's going to be a split trial. The trial will be divided into two phases, with the first focusing solely on the assault claim and financial implications, only addressed if she is found liable. Excluded information, the judge will block any mention of Cardi B's prior bad acts. So somebody asking about prior bad acts will be excluded. That would have been an motion in limine. So no, including her past as a stripper, prior altercations, or financial details to prevent jury bias. So the court is not going to allow the bad acts. We talked about that part. We talked about L.A. Reid is headed to trial and he's pro se. His attorneys have withdrawn. And then we have Cardi B is headed for trial on Monday, of which they're going to have jury selection at that time. Thank you, Sherman, for the super chat. I appreciate it. Y'all hit that like button. All right, so let me see if I can find an article or something. So Cardi B is scheduled to testify. Hold on, y'all. Oh my goodness. Cardi B is supposed to testify in her own, they say, defense. Let me see if one of these are gonna, let's see. Can y'all see that on there? Yeah. Let's see. Cardi B scored a legal victory this week ahead of a trial next month over claims she assaulted a security guard in 2018, according to Rolling Stone. A judge ruled in the Bronx rapper's favor on Wednesday, July 30th, granting a request from Cardi B's legal team. Cardi has maintained that the security guard, Imani Ellis, was the aggressor, trying to film her at her OBGYN's office while she was visibly pregnant with her first child, but before she publicly announced to the news. So yeah, she sounds like she was trying to get the scoop and videotape it so she can say, girl, I saw Cardi B up here at the OBGYN center. And they like, Cardi pregnant? And Cardi was like, no, I'm about to take your phone. You know how Cardi talk. I'm about to take your phone. She probably was all talking fast and all of that. A Los Angeles County judge granted the request from Cardi's attorney to split the trial into two parts and only allow mention of her finances if she's found liable during the initial phase. So they can't talk about finances or anything unless they say she's guilty. Now I'm saying it. Unless they're saying she's liable for the assault. The judge also agreed to block any mention of so-called prior bad acts. So all the stuff she done in the past, we're not talking about that. Cardi argued in court filings that any mention of her prior alleged altercations with third parties, police reports, obscenities, drug-related incidents, gang affiliations, exotic dancing, and media coverage would be highly prejudicial and distract from the facts of the case, to which the judge agreed. Ellis's attorney asked if the ruling meant he couldn't ask Cardi whether she struck someone before. The judge said this was off limits. Don't ask her that question. So then the judge said Cardi would have to initiate that line of questioning. So she has to open the door. So her lawyers got to be careful not to open up the door, or they're going to talk about her prior bad acts. If she says, I've never hit anyone, and you have credible evidence that she hit someone before, then yeah, you can bring that up, the judge said, but you can't force her to open the door. So if she just happens to be up there and she get to talking and talking and talking, and she like, I ain't never hit nobody, then they gonna be like, oh, okay. Isn't it true that on this date, you pled guilty to busting somebody upside the head in a strip joint? Isn't it true that you was on Twitter acting like a fool? Isn't it true that you are accused of throwing a water, getting mad at somebody throwing water or whatever it was, and you threw a mic? They can just go through the whole, and that would go against her credibility, obviously, and that would like jack her up if she did that, because the jury probably would be like, well, if you lied about this, what else did you lie about? So the judge said you can't talk about it unless she opens up the door. So hopefully she'll be prepped tight. Well, she ain't. She gonna stay away from that. The judge ruled that Cardi B, her prior acts have no apparent probative value, so any reference would be unduly prejudicial and likely to confuse the jury and result in an undue waste of time. The judge also granted 2 other motions that asked to block testimony from a former police officer and psychologist. The trial is set, this says, to begin August 11th, but it was moved because there were a few motions filed because the lawyers were not available. So there's that. So Cardi's on her way to trial. So it's so many people over there in California that they'll probably be over there covering it. If Court TV or anybody, there was something filed for media. So I don't know. It's up to them, just like the Tory Lanez trial. I wish that trial was streamed, because it would debunk so much that we have not seen any new nothing yet. Because a lot of that stuff the jury considered, and it was, they didn't like, they still ruled the way they ruled, knowing the evidence. It wasn't like they didn't consider it in their decision. And I wish that was definitely streamed, because the mixed reports that people gave because they liked Tory Lanez was just crazy. Because I was in the trial like, dang it, are they hearing what I'm hearing? But anyways, hopefully, I would hope that it's streamed. Like I said, there was a document for media. Yes, it was after the incident, but it's still considered, they can still try to use, but the judge ain't letting them use nothing, so it doesn't matter. Will this case hurt her? Are you saying hurt her to the ex-husband in a divorce? Or will this case help her so to be ex-husband? And will it her soon to be? Will it hurt her soon to be ex-husband? And well, when it comes to divorce, it gets messy and you bring up everything. Now, whether it's considered as, I'm sure she got things that she'll say he ain't the best person. So it'll be back and forth. So hopefully they think about the kids and they don't allow it to get nasty like that. But that's exactly why I don't do family law. Because I'm like, you don't want to be with them. Like, why are we really going back and forth? I know some things can't be helped. And so I'm not saying that it should, it's an emotional situation. When you have divorce, it's like a death. But people be acting a fool. That's all I'm saying. And I couldn't take it no more. I was like, I can't do this. Yeah, on the 20th, it was a media request to photograph, record, or broadcast. And there's an order. Let me see if they filed the order, because, baby, if they do this is where we going to be at on Monday. We're going to be over here streaming this joint. Oh, here go the order. Do I got to pay for this order? Hold on. Because it wasn't there yesterday. No hearing was there. Oh, they granted it. The local rules of this court regulating me outside of the courtroom. The media agency shall demonstrate to the court the proposed personnel and equipment. It's pool coverage only, no live coverage. Dang. Darn it. Who is this though that's trying? Oh, Court TV. They're going to have, so their Court TV is going to have video of it, but apparently the judge is not going to allow them. Let me pull this up for y'all. The judge is not going to allow them to stream. Darn it. No hearing was held. They granted it. It's pool coverage, so they can't stop us from watching. They can't stop us from like sharing it and using it. No live coverage. All proceedings except those prohibited by California rule, and those proceedings prohibited by other court rules. Dang it. Let me see who else tried to. You said darn. We still gonna like look at it though. But wouldn't that have been dope to watch that live? That's why I said I know in California it's up to the judge. And I wish the person in Tory Lanez are really. Oh, it's only one order. That's in there. And it's pools. Oh, shucky ducky. Thought we was gonna have our stuff together for Monday. We'll probably still try to go. Well, Monday is jury selection, so. Unrelated to this topic, Pam, have you mentioned a Bishop Ellis out of Detroit before? I've been going through old lies trying to see. No, I never talked about Bishop Ellis. I probably explained why I haven't talked about. I don't think maybe I didn't explain out here. May have explained it in the membership, but I couldn't really talk about Bishop Ellis. I'm just gonna leave it at that. Well, about that situation. Tracy said, girl, L.A. Reid broke and he's going to represent him. So Lobster Hood and Ghetto was trying to help. We was trying to help him out. We just over there on the other platform trying to help him out over there just to see. That might still be a good one. We might have to do that this weekend to see what we're going to be able to do to help. All right. So now we done talked about Cardi B and them. We done talked about L.A. Reid. Those are the upcoming dockets and trial, so govern yourself accordingly. We got Lil Nas. He just got arrested facing battery charges for allegedly assaulting a police officer. They showed him earlier talking about he was hospitalized because they thought I thought he was trolling. I was like, why is this news? You know he likes to troll. We ain't talked about him in a while. But apparently they saying he actually was for real because he didn't call him a case allegedly. But anyway, all minds clear. Make sure you guys hit that like button, subscribe to the channel. You said T.A. Blaze, I don't believe he's broke, but maybe cocky to represent himself. No, I think, do I got that letter on L.A. Reid? Let me do that real quick too before I get off because I was, what's it? Conference trial brief scheduling order. It was something I read in that case. It was a letter. Hold on. Was it a status report? No, it wasn't that. See, this is what happened when you just reading so much stuff. It was a letter. Okay, hold on. We got one more thing. These are all one page. I could do that. So. Was this the one? No, that was about certain evidence. And they had text messages. Let me see who these text messages belong to. See if we care. Oh shoot, they said it's filed under seal. Gonna waste my money clicking on that. Let me see. And they did file a motion to compel because he hasn't turned over some stuff. Let me go to the motion to withdraw. Motion to withdraw. So we can see why he withdrew. Why they withdrew was back in June. Let's see. Motion to withdraw as attorney. Okay. So we can be clear as to why there was a withdrawal. Hold on. So here's the declaration of Sean Holly. Hold on. Let's see if this gives us some type of insight. L.A. Reid ain't broke in my opinion, but he's don't want all his money on his attorneys. Well, I think maybe it might be he just like it's cheaper to go ahead and get a default. Maybe he thinks that, I don't know, but he might get hit with some punitive damages. I don't know. They say he who represents himself has a full foreign attorney. Just saying. So this is Sean Holly's declaration to withdraw. So she says she's the partner. Mr. Reid was also previously represented by Bobby Stein, Esquire, who served as local counsel to my firm. So she pro-hoc in because she's from California. There has been a breakdown in the attorney-client relationship between Mr. Reid and my firm and my partners that precludes our continuing representation of him in this matter. Several months ago, Mr. Reid stopped paying my firm's bills. My partner and I have nevertheless continued providing services and incurring substantial additional fees and expenses in taking expert discovery and in preparing and filing a dispositive motion and 2 Daubert motions. Those are experts. When it comes to your experts, so they're probably challenging the other side's experts and was requesting a hearing or to exclude them, saying that they may have been an expert, maybe not in this field, or they may say they're not an expert, but you're challenging their expert. All with the expectation that Mr. Reid would come current on his bill. But Mr. Reid has persisted in failing to pay any of the substantial balance that is currently owed to my firm, despite repeated requests. Mr. Reid has further been uncommunicative concerning his payment of attorneys' fees and costs. My firm formally wrote to Mr. Reid on May 23rd, 2025, to arrange for a payment of the firm's invoices and to indicate that the firm would have no choice but to withdraw if the fees were not paid. Mr. Reid failed to respond to the letter. He just was like, I can't see it. I can't see it. My firm, my partner, and I cannot afford to continue representing Mr. Reid without compensation. All fact and expert discovery in the case is complete. A motion for summary for adjudication and Daubert motions to exclude plaintiffs' disclosed experts have been filed by my firm on Mr. Reid's behalf. Financial discovery is ongoing in this case. Trial is scheduled for September 8, 2025. This motion to withdraw is made after my firm and I have exhausted all efforts to obtain payment for our services, and at a point in time at which Mr. Reid will have sufficient time to engage replacement counsel for the September 8th, 2025 trial. I'm not asserting a retaining or charging lien. So they were going to leave and they weren't even going to put a lien on the file. My firm has informed Mr. Reid of our intention to file this motion for withdrawal of counsel absent his payment of the firm's invoices, and Mr. Reid has not responded. Wherefore, I request that the court enter an order permitting me and attorneys Gregory Korn, Kate Mangles, and Sue-Ann McIsaac to withdraw as counsel of record for defendant Antonio Marquise L.A. Reid in this action, and that's that. So that was the actual motion to withdraw. So he wasn't paying. Okay. Angelique said, pay them people. T.A. Blazin said, oh, allegedly Reid doesn't pay the bills. Listen, that's what they said. He may pay some bills, but he's not paying theirs. Let's see what this one is. Oh, they all did their individual requests that's similar to Sean Holly's to withdraw. That was it. She is definitely a beast. Sean Holly is by far, you talking about somebody that was on the O.J. Simpson trial. Sean Holly is by far, and her husband is a lot of people don't know about her husband too. He's like a musician, a singer, and I think he did like backup for Michael Jackson or something. He was going to be on the This Is It tour. He ain't no joke neither. But Sean Holly is the GOAT. Just say she is one of the best attorneys that's out here, and she learned from the best as well. And a lot of celebrities use her. I think she's on a couple of Diddy's civil cases. Diddy must be timely paying his invoices. So, but L.A. Reid, apparently he's not timely paying his invoices. So that's that. That part said if they got receipts, he is cooked. Angelique said, I saw an HBO documentary on a sister who was in the music business, and L.A. Reid was one of the men who harassed her. So also, I forgot what I was going to say just that fast reading it. It'll come back to me. Tracy said Phaedra Parks might take the... Did you see her on Real Housewives when she was representing Sheree against her husband that was pro se? Did you see that? Just asking for myself. Yeah, Sean got a couple months. Listen. Yeah. One of the things so I don't know if it's a strategy, because one of the things Tasha K said was she wished in the Cardi B case that she would have just defaulted. Because remember, Tasha, and I don't remember what I was going to say. Let me finish this with Tasha K. Tasha K, the person that told Tasha K all of these defamatory statements, was sued as well. And she never responded. When she didn't respond, she got like, she's the one that came up, gave all this information allegedly to Tasha K. She never responded, and I think she got a default judgment for like 100 and something thousand or 200. It was like in six figures. So Tasha K's like, she alleged she was paying her lawyer, who was a criminal defense attorney that had never really done civil. Allegedly, she was paying her 20, 30K a month or something like crazy. Tasha K got some real lawyers now. She got some of the best First Amendment lawyers in the United States. She leveled up after that case. But she did the bankruptcy situation, of which, was able to stay all these cases. So until the bankruptcy was complete, every time somebody sued her, she could just show them that she's in bankruptcy, and they have to stay the case. You just put them in bankruptcy or whatnot. So she kind of learned how to maneuver. So she said she wish she would have got a default. But you're kind of playing Russian roulette. Like, what will the judge come up with for an amount? But will a judge be more reasonable than a jury that goes on somewhat of their emotions? That what if they are outraged by all of this? And so he's like, forget it, I'll just get a default. Like the judge just basically threatened, and like the judge said, may happen if you don't show up for this pretrial conference on Monday by yourself, or if you don't have a lawyer to come in. I don't see a lawyer coming in a week, 2 weeks before trial. They may do it. I've done it before where the weekend before trial, I took over a trial. But for the most part, you're not trying to do that. You want to be well versed in the case. You want to be, and the judge said it's, it's going to happen. It's a firm date. So you better do whatever you're going to do. And you better show up to this pretrial conference, because if you don't, you may get a default. But apparently the communication has been rough because, again, Sean Holly's team, he hasn't been communicating with them. So even they've said, okay, yeah, you are required to see the financials, but I can't get in touch with them. That's part of the issue. It's a breakdown of the relationship. So I can't even get in touch with him to get the finances. So what if that's just a part of him? He like, I'm just going to take my chances, and then I'm going to see if I just get a judgment that ain't that bad. And that could be strategy. I don't know. Very risky. But who knows? Rock Nation update. Okay, Demore. I don't know. That might be a whole nother live. So they're going back and forth. Demore. Oh, yeah, that got to be another live, Tracy. That's a whole. That's a lot of situations to be talking about. But briefly, Rock Nation, well, there's a gag order in the case. And Demore Hadley, who is the daughter of Desiree Perez, the CEO of Rock Nation, has sued her mom, Rock Nation, the hospital, all of that, claiming that she was wrongfully placed under the Baker Act and other allegations within the complaint. Well, the problem was Demore, when it was filed, it didn't really get that much traction. Like, it was filed for a minute before it got any traction at all for anybody talked about it. I ended up randomly being on one night, and I decided to get on there and talk about it. So I get on there to talk about Demore. She watches the video. So she's lurking on the internet, going in comments, trying to see who's talking about her. So she comments, and she basically tells me to read some document, that I got it all wrong. You could have just reached out to me and asked me to come on, just things like that. So I knew then, I'm going to say, in my opinion, I felt like she filed this lawsuit in order to get the public attention that she's getting, in hopes that it will force or pressure her mom and Rock Nation to settle. That's what I felt. Why? Because I'm in this game and I know what some people try to do. So I didn't really entertain much of it. As you guys know, I think the video was private now. Like, I didn't even like the video where I talked about her. I wasn't even trying to give her much attention. So there ended up being a gag order. So of course everybody was dragging Rock Nation. There they go, silencing people again, So the thing is, people hate Rock Nation, and they have all of these different assumptions about Desiree. I don't know none of these people. I think she did show up to the Tory Lanez trial because, of course, Meg Thee Stallion is a Rock Nation artist, or was one. I don't know what position, where she is now, but at that time when the Tory Lanez situation happened, she was. So everybody was using this as a way to go off on Rock Nation. So you saw a bunch of me, and maybe I think Conscious TV that I saw, and it may be others. I don't know every YouTuber talked about it for what it was, like what was filed. We was going in what was filed or whatnot. A lot of people went the other direction. It was poor Demore. They doing this, they doing that to her, blah, 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 blah. So Desiree's attorneys have filed a Rule 11 sanction. We've been going over that in the last couple of videos. So if you don't know what that is, go look at those videos. They was doing a Rule 11 sanction against trying to do it against the attorney. Essentially, they've gotten jail calls. They've gotten text messages. They've also, one of the things DeMore was saying was some of the pictures of her bruises and scratches and all of that, she was alleging they were AI. Well, according to Desiree, they have gotten the metadata, remind you of the balcony incident in the Diddy trial. They went and got metadata to prove that they were real pictures that came from her phone. They also got jail calls from her husband after he went to jail for assaulting DeMore. There's a transcript of which he is basically saying, I'm coming after her for money. I'm coming for her pockets type deal. So they got all these transcripts to show what the plot was. So this is what they are alleging. And then her, of course, and the attorney, they went on it all started when they went on the news. But they were trying to get traction for this to basically say they know that hurting her reputation would be the biggest. Basically, we're going to hurt her reputation in order to pressure her to settle, is what they're alleging by some of the information and the documents that they've had and they've been able to find to support their claim. So they're asking for sanctions to say like what the purpose of this was not a legit purpose. They said they've shown there was, I guess it was a recording device. They were saying Desiree was gang related. She was listening to them have sex, things like that weren't true. And so she showed like they had a security camera. That's where it came from. So basically they've gotten their forensic expert to show that a lot of this stuff was meant to come against them. And I guess there are actual transcript, well, there were, because I've seen them, from the jail calls of the husband when he was locked up stating that he was going to sue her arse, meaning Desiree Perez. So that's the cliff notes of what's going on now. But yeah, there's a lot of attachments to it that they had as proof. So that's why I said it would be a separate video to be able to pull it up and show what evidence they are attaching. Hey, Angelique. I'm going to have to look at that. What streaming platform is that about LA Reid? I don't think I saw one. Seen one. What if LA and Bollywood wrestle? So what's interesting, Tracy, and thank you, that actually triggered my memory again. What I was going to say that was very interesting is when you looked at the complaint that was filed by Drew Dixon, she mentioned Russell Simmons a lot. And I remember in my video that I did, I was like, why isn't she suing Russell Simmons the way she keep bringing him up? Well, I believe she did end up filing something against him. It might have been under I don't know if it was under Jane Doe or whatever. But as you guys know, cases, there's been two cases, one in state court and one in federal court that was dismissed against Russell Simmons because he is not, the courts don't have jurisdiction over him. He is a citizen of Bali. So yes, Russell Simmons' name was brought up a lot in this case with Drew Dixon. So HBO Max. I don't know. Yeah, I think I got that free with AT&T. I just ain't never used it. I'm like, child, if it's on a streaming platform that I ain't got, I'm not getting another one. I already got Hulu, Peacock, Amazon Prime, BT Plus. It's like they spread out all these movies and shows you want to watch, and you got to pay the app. So I got to wait. Like Hulu, I wait till they got like Black Friday and it's 99 cents. I think BT Plus, I just connected it with Amazon Prime. So it was only about $5 a month. Like you got to find a way to maneuver that. You mess around and you got 10 apps that you paying for, and then they come taking it out your account. You really want to hit that fraud button, but you know, in theory, you actually were the one that ordered it. You just forgot you got all them apps because you done watched that show that you wanted to watch, and now you forgot to cancel it, or you don't even remember what card you put it on. That's my story. Man, that's it, AK. That's the lick right there. Angelique said yes, Drew Dixon is the who the documentary is about. Okay. Let me watch. I'm sure that'll be whatever she said in there. That'll come up in court. Interesting. She was considered the golden ear in the music industry back in the day. Yeah, she looks like the goat. She sounded like the goat by the songs they mentioned. And she was supposed to bring in Kanye West. You know, he was hot during that time. So she does have a gift. Yes, I saw that. He's been arrested as well, I guess, for assaulting a police officer allegedly as well, Nas X. So yeah. All right, y'all. I'm out of here. Thank y'all so much for coming over and supporting. Make sure you hit the like button on the way in. For those that come in on the replay, make sure you hit the like button and subscribe as well. And we'll be back to do it all over again, Lord willing. You guys have a good day.